चलिए लिखिए, ये आपका हो गया कोर्ट का PLJR मैगजीन है, टोटल वर्ड 800, जो अप्रैल का ये PLJR है 2019 में है, उसी का है पटना हाई कोर्ट के लिए। ऑडियो को लाइक करें, शेयर करें और सब्सक्राइब करें। बाय एमडी सद्दाम, मोबाइल नंबर 9507142555 इन पटना। रेडी स्टार्ट। आप अगर चाहते हैं पर्सनल डिक्टेशन और PDF के साथ तो यूट्यूब पे तो वो तो है ही, 500 रुपया तो है ही। पहले पर्सनली हमको कांटेक्ट करें, ठीक है, व्हाट्सएप पे आपको मिल जाएगा। रेडी स्टार्ट। पटना हाई कोर्ट के लिए सेक्शन 125 रिस्पोंडेंट फाइल्ड एप्लीकेशन क्लेमिंग मेंटेनेंस अंडर सेक्शन 125 फ्रॉम appellant husband for herself and her minor daughter SDJM awarded rupees 2000 per month towards maintenance for her minor daughter, but rejected application relating to award of maintenance to wife on the ground that she is not the legally married wife of appellant high court in criminal revision petition filed by respondent wife set aside order of SDJM and remanded the case to SDJM to decide application of respondent afresh. High Court having recorded a finding of fact that respondent is the legally wedded wife of appellant, should not have remanded the case to the SDJM for any inquiry and should have fixed the maintenance payable by respondent and appellant to respondent in revision itself, more so because respondent is not earning and has no independent source of any income to maintain herself, the need to remand the case to SDJM is called for any when some factual inquiry is required to be held to decide any factual issue involved in case which cannot be undertaken at the revision stage, or when it is noticed that there is no finding on any particular factual issue under bracket S recorded by the SDJM, or when additional evidence is filed for first time at appellate/revision stage, which requires examination by the SDJM in the first instance, and to record a finding in the light of such additional evidence. Appellant working as constable in RPF, having salary between rupees 30,000 to rupees 35,000 per month, maintenance fixed at rupees 8,000. Stop para. Sections 154, 190 and 200 Constitution of India, Article 226, prayer for direction to authorities to submit action taken report on complaint filed by complainant petitioner filed complaint against private respondent medical officer, before civil surgeon, but no complaint was filed against him before superior authority of a state government. Petitioner also filed complaint before officer in charge of Mahila Police Station and other officer, but did not send substance of such complaint to SP on their failure to institute case as required under section 154. Thus, C did not avail a statutory remedy provided under section 154 under bracket 3 and under sections 190 and 200. Read petition dismissed. Stop para. Section 190. Cognizance on the basis of second supplementary charge sheet. In first charge sheet, respondent was referred to as a suspect, and in second supplementary charge sheet arrayed as accused number 1 at the stage of issuing process, the magistrate is mainly concerned with the allegations made in the complaint or evidence led in support of the same, and magistrate is only to be satisfied that there are sufficient grounds for proceeding against the accused when issuing summons, the magistrate need not explicitly state the reasons for his satisfaction that there are sufficient grounds for proceeding against the accused. In summoning the accused, it is not necessary for magistrate to examine the merits and demerits of case and whether materials collected is adequate for supporting conviction. Court is not required to evaluate the evidence and its merits. A standard to be adopted for summoning the accused under section 204 is not the same at the time of framing the charge at the stage of taking cognizance of the offence based upon a police report, and for issuance of summons under section 204, detailed inquiry regarding the merits and demerits of the case is not required. In cases instituted on a police report, the magistrate is only required to pass an order issuing summons to the accused, and such an order is based upon subject to satisfaction of the magistrate considering police report and other documents and satisfying himself that there is sufficient ground for proceeding against the accused, and the magistrate is not required to record any reason in case, if the charge sheet is barred by law, or where there is lack of jurisdiction, or when charge sheet is rejected or not taken on file, then magistrate is required to record his reasons for rejection of charge sheet and for not taking on file cognizance of offence was taken by taking into consideration charge sheet filed by the police order for issuance of process without explicitly recording reasons for its satisfaction. For issue of process does not suffer from any illegality. Stop para. Sections 190 and 204 mensra can only be decided at the time of trial and not at the stage of issuing summons when prosecution relies upon the materials, a strict standard of proof is not to be applied at the stage of issuance of summons, nor to examine the probable defense which the accused may take all that the court is required to do is to satisfy itself as to whether there are sufficient grounds for proceeding before summoning the accused, the facts stated will have to be accepted as they appear on the very face of it for issuance of process against the accused, it has to be seen only whether stop. चलिए इसको सब्सन कीजिए, इसको मिला देते हैं।